Hi, I'm Darcel Lobo and I own Dow Law Firm in Normandy Park, and today we're going to talk about selling a home that's in a probate. So somebody has passed away and you've been named either the administrator or the executor of the estate, and there is some real estate that you need to sell. Maybe that's the decedent's home where they lived, maybe it's a rental property, investment property, whatever the property is, you need to sell the real estate as part of the estate. So the first thing to start with is, if you've been appointed, is confirming if you have what's called letters testamentary or letters of administration. And that will depend on if you were named in the decedent's will to act as the executor of the estate. So if you were named in the will to act as the executor or personal representative, it's the same thing, you will have what's called letters testamentary. If there was no will, or if you're acting on behalf of the estate but you were not named, maybe the person who was named is unable to act, then you may have letters of administration. So you want to understand what kind of order you have from the probate court, and you want to confirm if there's a bond requirement and if you have non-intervention or full intervention powers. If there's a bond required, then you would have had to obtain a bond from an insurance company to protect the creditors of the estate. If there is non-intervention, that means that you do not need court permission every time you want to take an action with the decedent's estate. So for instance, selling real estate. If you have non-intervention powers, then you don't have to go back to probate court when it comes time to sell this real estate. If you have full intervention, that means the court is overseeing every step along the way of the estate, and so you have to get permission to sell that property through the probate estate from the probate court. So you want to have an understanding if you have letters testamentary, if you have letters of administration, and if there's a bond requirement, as well as if there's non-intervention or full intervention. So once we figured out that, we're going to proceed to find an agent. You can use any agent of your choosing, generally speaking. So most of my clients, they'll talk to a few agents, figure out which one is the best fit for them, and go with him or her. And so when you're listing the home for sale, the first thing to take note of is on the listing agreement and the listing paperwork, make sure it is not you individually who is listed as the seller. Even though you're the one who'll be signing all the paperwork and making the decisions, it is not you selling it in your individual capacity. You are selling it on behalf of the estate. Therefore, the seller in all the paperwork should be the estate of and the decedent's name. Now, you will be signing the paperwork as the administrator, as the executor, as the PR in that capacity, but the seller should be the estate of and the decedent's name. And along those same lines, you want to make sure that you have a tax ID number for your estate. That can be obtained very easily. Once you've been appointed by the probate court, you'll go to irs.gov and apply for a tax ID number, also known as an EIN, but that's the number that will be used with escrow as far as reporting the sale. You want to make sure that they are not using your personal social security number when it comes time to report the proceeds to the IRS. It needs to be reported in the estate's tax ID number, their EIN number. So make sure you have that ready when you are moving forward to list property for sale. I generally do it for clients as part of the process of our probate services. We just obtain that tax ID number for the client. Once we have our letters testamentary or letters of administration, we obtain that right away. But if you don't have that yet, if you don't have an attorney helping you, you want to make sure that you go online and get that tax ID number for your estate. So now we have the seller's name, we have our tax ID number, and so as part of your contract, there's a few things to take note of. Is that here in Washington State, generally speaking, most sales require that you complete what's called the Form 17, which is a seller's disclosure form. But probate estates are exempt from having to provide that form, because as the executor or as the administrator, you don't have the first-hand knowledge about that property to be able to provide that form to a buyer. And so because of that, under state law, the estate is exempt from having to provide Form 17. So you want to ensure that there is no Form 17 or seller disclosures form being included with the sale of the home. So your agent may or may not know this if you're using an agent, so make sure that they're not requiring that or asking you to complete one, and you'll want to ensure that your contract has a term in it that says that this transaction is exempt from Form 17. As a part of our services, when I have a client selling a home, we prepare a full addendum that goes with the purchase and sale agreement that references the property being exempt from Form 17 due to it being a probate sale. Also, when you're selling real estate from an estate, from a probate, there's going to be a different type of deed that is used. Generally speaking, most transfers of real estate in a sale are done via a statutory warranty deed. That's not the type of deed that should be used when you are selling real estate in a probate. You instead want to use what's called the PR deed. Our office prepares that for our clients when selling a home, and it limits the liability of the estate when selling the property. And so you want to make sure that you have that type of deed that's used when you're selling real estate and a probate. And then when it comes time to actually closing on the sale of the home and escrow is dispersing funds, the funds from the sale of the property should be going directly to the estate's checking or savings account, not your individual account. They should not be making distributions to any of the heirs directly. The sale proceeds from the sale of the real estate need to go into an estate checking or savings account. And so when we've obtained a tax ID number, we inform our clients, you need to open an estate checking account, close any accounts that are in the decedent's name, close those, put the money into the estate account. The sale proceeds comes into the estate account that you're using to pay for the estate's expenses and pay any kind of debts and things for the probate, things like that. And so the funds from the sale of the house and escrow should be going directly into that estate account for you to administer once you've settled all the other assets and all the other debts. So that's a short overview of selling a house in probate. If you have any questions, give us a call. Our number is 206-408-8158, or visit us online at www.dallawfirm.com, which is DALLAWFIRM.com. Thank you.